So this episode, we're going to be looking at boundary disputes, party walls, one of my favourite topics of all. Now, over in England and Wales, over 80% of land is now registered with the Land Registry. So where does this leave us now? So we're going to be talking about different aspects of how things have changed over the years and where we've got to today. So what a lot of people don't realise, that we get given these topics literally just before the day before.
Yeah.
So if this isn't going to be interesting, it's certainly going to be fun. so let's go with this then. Have you got anything for us?
So, Dan, what is a boundary dispute? What does it cover?
Wow.
Where can it arise? You know, I know it's broad, but I'm thinking hedges. I'm thinking fences.
Karen's paying for this, you know, and this is going to be expensive. So let's go with it. Let's try and niche it down to a little bit. Right, boundary disputes are quite commonly, as a mediator, I get to see most of these live, and it's one of the most upsetting parts of boundary disputes is the mere height of trees, the fence lines and things like this, and it really is disappointing because. You go back years, or actually not that long ago, but one of the most famous cases, I don't know whether anyone knows about this, but it was up in Lancaster where £100,000 legal fees was argued over an inch of land.
Yeah.
Oh, do you remember it?
Yeah.
Yeah, oh well.
Wasn't it, but the wall went an inch over and the judge was there throughout the entire thing saying, what are you all here for?
Yes.
In the judgment. They're expecting this extension or this build, I can't remember offhand what it was, to be knocked down. I mean, what? Of course, no one's going to knock down someone's house over an inch over someone's land. It was just perplexing, the entire situation.
And the strange thing is, and what I've learned over the time of mediating, certainly as opposed to in the courtrooms, is the Land Registry. There is what you've got the boundary lines, and you've got your T's and your H's that we refer to.
Yes.
So the T on your side obviously reflects the fence that you own, and the H means that you effectively two T's looks at you both share that traditionally. Yeah. But with land, it moves. It's not a stationary thing. It's not an actual permanent thing. Land will move through flood waters, and we're seeing a lot of that lately. So there is a understanding that whilst the Land Registry might give you the boundary line, interestingly, that
it doesn't always align with what's actually on the ground, is what.
Quite. I mean, if you've ever looked at the Land Registry plan, it actually says that this is not accurate. And it doesn't pretend to be.
Yeah.
Because what's it based off? It's based upon the conveyances plan, which is based upon Mr. Bloggs drawing it up. And then you marry you and your neighbour's plans together, and there'll be gaps, there'll be overlaps, because it's not designed to be like an ordnance survey map. And people just don't get that point. And they will have feuds going for decades without understanding that point.
They can get really heated.
Oh, it does. It does. One of the most common forms of disputes is neighbouring disputes.
I know.
And then you've got to continue living with them afterwards. But that's another topic. It really is. So party walls then. Party
walls. So this is less, it doesn't resolve boundary disputes as such. It's more just concerning boundary lines.
Yes.
But very special ones, isn't it? Or very particular ones, rather.
Yeah. So a party wall is anything that's shared between two properties, or, well, actually, it doesn't have to be that either. The Act comes into play when there's work being done on a property that will affect another property. So, for instance, taking down half of a chimney stack, that comes under.
So where it's a shared chimney stack and things like that, and shared walls.
Yeah.
Yeah. Okay.
And actually, if you're considering doing work, I think it's within 3 meters of someone else's boundary, you have to serve them with a notice. All of those works need to be. You need to serve your neighbour with a notice.
Within 3 meters.
Yeah.
I didn't know that.
No, I know.
It's amazing.
Most people don't. Like, it's not a common.
That's what I'm learning here.
Yeah. But basically, otherwise it can be disputed, and they can take you to court for an injunction against the works.
Right. Yeah.
But once you serve your notice, they can either agree to the work you're doing, or they can ignore it, or they can appoint a surveyor, to come out, and then they draw up an award. Both neighbours appoint a surveyor to draw up an award, which basically lists what work's going to be done, when, how,
Makes sense,
yeah.
really.
Oops.
My understanding is when the party wall surveyor draws up the award, it's the person who's basically infringing who has to pay for that.
Oh, yeah. Totally.
So yeah, party wall surveyors are well worth knowing and using. They really are very specialist and they really know their stuff.
Yeah.
They can really solve an awful lot of problems.
And it just avoids structural damage to both parties' property. It's a really crucial bit of law that not many people know about. So yeah,
well, we've discovered that quite a few builders, major builders, either ignore it. Quite a few housing associations, again, ignore it. So it is a right which quite a few people because we're a nation of terrace housing and semis. So quite a few people, it will affect you at some stage.
Yeah.
And I suppose when you look at the way the country's going, we're building more houses. Villages are becoming towns are becoming cities, etc., etc., and it's becoming expanding.
Yeah.
So disputes are going to be, we see a lot more disputes. So you're naturally, by its own nature, going to have more disputes because you've got more people living in more houses, and you're going to have more disputes, etc.
Yeah.
And we've got an ageing building stock. What we have, repairs are going to be needed, maintenance. And you don't want to wake up to find the builder has knocked through your wall because they don't know what they're doing.
Yes.
Exactly.
So should we move on to our first possession?
Yeah.
It's exciting. Sorry.
I think Dan's getting quite excited.
Yeah, sorry.
So,
I don't normally.
adverse possession. Tell us the two types.
Oh, you've got me there. What do you mean by adverse possession? As in intent?
No, the two types of adverse possession.
The 10 and the 12 year.
Oh, sorry. Yes. Okay. Yeah, I've got you now. So you've got squatters' rights. You got the Land Registration Act, which changed in 2002, where you have to register land under certain criteria. And that's the reason for it. So you've got the 12-year rule, which we talk about squatters.
And
rights.
that's the old system.
Yes.
So my understanding is if you've accrued rights, as in you're a squatter for over 12 years, prior to, October 2003, a specific date when the 2002 Act came in,
Yes.
then you still operate under the transitionary rules, which are basically the old rules.
Yes.
So 12 years is when you can start accruing your rights if you're in adverse possession.
Adverse possession. And then we've got into the points of how we established that. Then you've got the 10-year rule now.
Yeah, that's the new system.
Yeah.
2003 onwards, that's the new way, which gives more rights to the landowner, doesn't it? So I think the old one, the adverse possession, would basically kick out the landowner's rights at a certain date, except if you objected in the correct way. But the new one provides many more protections for the absent landowner.
Yeah, and I suppose the claims traditionally, if you look at the two acts, when I looked at the two acts, squatters' rights were very much at the forefront because land wasn't registered prior to 2002. And there was a lot more land. And there was a lot more opens, albeit that we'll talk about the fencing and the buildings and the different parts to that. But nowadays there's less land and it is registered. So it goes back all the way to medieval times, actually, when the crown owned it all as well. And then you had to prove it's a squatter's right. And if you look at the two acts in 2002, which is quite interesting, I thought, anyway, but then I'm boring. You don't have to agree.
No comment.
You have a look, and the adverse possession now goes to the back of the act. So when you make a claim, it's at the latter end of the section. I think it's about section 36 or 37. But if you look at that, it's interesting how the act has changed because society doesn't actually conform to this, I've got a right, because it's harder to obtain those rights now, I would say.
It's much more controlled, I guess, and in the sense that the moment we have a registration and the prevalence of registration means that the type of thing you're going to protect is slightly different. But getting on to what are the 3 points which you need covered off for adverse possession? Testing your memory here.
Yes, you are. It certainly are. You've got to have an intent.
Well done.
Yes.
And that's the intent to possess. Well, probably best to go to the first one, which is factual possession.
Oh, yes, I
It's
suppose,
pretty
yeah.
obvious. You start your fence round whatever property.
Or building, I suppose. Yeah.
And then you've got to have the intent to possess what you put the fence round, which
Yes.
always confuses people when you're trying to explain it to them. But there's a subtle difference. It's almost like saying, I put the fence round it, but I don't really care. And the next one is, but I really care.
Yes.
I really want that to be my land. And one follows from the other, really. If you don't have factual possession, you can't have the intent to possess.
No, by its own nature.
But you can technically have factual possession without the intent to possess. And that really confuses just about everyone.
Absolutely. And I think then you look at, you got to have used the land for the purpose of what you're using it for.
Yep. And that it's almost like a sort of fact-finding thing, and how you use the land will inform both factual and intention, but not necessarily entirely.
Because it was unusual, because I remember a case, and excuse me, because I can't remember the name of the parties at the case, albeit it's going through my mind now as I'm trying to talk. But what was interesting to me was the gentleman that walked across the horse field and then claimed the field that he was walking across and had been doing so.
Yes, I think I remember that from oh my god, so many years ago.
The gate was locked, shut, but he had a key. That was it. He had a key to the lock, which had been given to him by the farmer to use it as a walkway through a right of way.
Yeah.
And because he'd been given the key, the owner knew he was using it for the purpose of walking through, and then he claimed the land. And I'll have to get that for the next series.
Very true. Which brings us very neatly onto the final aspect of adverse possession, which is it has to be done without the owner's permission.
Yeah.
So how could he claim to have adverse possession if it wasn't, well, first of all, it wasn't possession, clearly. And secondly, it wasn't adverse in your instance. So he was given a license to use that as a path.
Right. Yes, because you can't claim it if you've been given a license, but I suppose it would have fallen under the old law anyway.
Even if it was under the old law, I'm surprised a claim even came about, because it's one of those sort of claims which you're taught at university where you're thinking, well, the criteria are pretty clear here. Didn't possess it, he just used part of the land, but at someone else's permission. So the test
would have failed. Yeah, I'll have to look up that case again.
Yeah, I suspect it was.
Board.
Yeah, from memory, I think that might have been a bit of a try-on from trying to claim a prescriptive right, as in I've used that pathway for long enough.
I can continue.
But also an add-on, let's have a go and see if I can get that field.
Yeah, we'll recall it. So there we go. There's our favourite topic, for me anyway.
Very brief.
If it wasn't interesting, I hope you found it fun. And we look forward to seeing you next time.
Yeah, thanks very much.